Welcome to SVR IAS Online Academy. Our website is commandindia.com. In this Polity online video lecture, we are going to see about Advocate General. In this video lecture, what you are going to see briefly, you will learn some introduction about Advocate General and what are the important articles dealing with the post of Advocate General and what are the qualifications needed to become an Advocate General, what are the important duties and functions of the Advocate General, what are the important powers of Advocate General, what are the various limitations on the powers of the Advocate General, and comparison of Advocate General with the Attorney General of India, comparing the Attorney General of India with the Advocate General, and this is very important for the prelims examination along with other topics. What are the important prelims point in Advocate General? Overall, the comparison between the Attorney General of India versus Solicitor General of India and Advocate General is very important. So let's start the video lecture on Advocate General. Advocate General is established by Article 165. Article 165. So the first important prelims point regarding Advocate General is it is a constitutional post. It is the constitutional post established by Article 165. Article 76 establishes the post of Attorney General, if you remember. And what about Solicitor General? It is not a constitutional post. It is a statutory post established by the Act of Parliament. Advocate General is the highest law officer, or you can say the first law officer in any state. Now let's discuss about appointment of the Advocate General. Advocate General is appointed by the Governor of the state. Governor of the state. If you compare it with the Attorney General of India and Solicitor General, both posts are appointed by the President of India. President of India, whereas Advocate General is appointed by Governor of a particular state. Now let's discuss about the various qualifications needed to become the Advocate General. To become the Attorney General of India, a person should have all the qualifications to become the Judge of Supreme Court. To become the Advocate General, a person should have all the qualifications to become the Judge of High Court. Remember the difference very well. Here, let's briefly discuss about the qualifications needed to become the Judge of High Court. Further details will be elaborated in our High Court video lecture. He should be a citizen of India and he must possess judicial office for at least 10 years. For 10 years, or he must have been an advocate in a High Court for 10 years. Advocate in a High Court for 10 years. Advocate not in the lower court. Remember, advocate in the High Court. Here, he must hold the judicial office not in High Court, below the High Court. You can say the District Court or any court for 10 years. So the person gets eligibility to become the Judge of the High Court. Here let's compare these qualifications with the qualifications needed to become Judge of Supreme Court. Here, Supreme Court qualifications and High Court Judge qualifications. Citizen of India, there is no problem. And Judge, a person must have a Judge of the High Court for at least 5 years. Here, to become a Judge of High Court, a person must be a Judge of or must hold the judicial office less than High Court for at least 10 years. And advocate qualification, he must have held the advocate position in High Court for 10 years in High Court. And here also the same, to become a judge of High Court, the advocate must hold the post for 10 years in any of the High Court. The last important difference is that eminent jurist. In the opinion of the President, a person may be eminent jurist can be appointed as a judge of the Supreme Court, but there is no concept of eminent jurist becoming the judge of High Court here. So governor cannot appoint a person as a judge of High Court in the category of eminent jurist. Now let's discuss about the term of office of Advocate General. As you know, Advocate General is appointed by governor. He does not have the fixed term of office. So Advocate General holds the office during the pleasure of the governor. Like Attorney General of India, he holds the office during the pleasure of the President of India. Whereas Advocate General holds the office during the pleasure of the governor. Constitutional posts like CAG or CAG, Judge of Supreme Court, High Court, Election Commission, etc. Removal procedure is very tough, so that it makes the office independent of the executive. To remove these constitutional posts, the motion should be passed separately in both houses with a 2/3 majority. We will discuss about this in individual video lectures. If you compare the Attorney General of India as well as Advocate General, these two posts are constitutional posts, but Constitution does not contain any procedure or grounds for their removal. It means Advocate General can be removed by the governor at any time. So it's an important prelims point. Remember that Constitution does not prescribe any procedure or grounds for the removal of the Attorney General as well as for the Advocate General. Now, resignation of the Advocate General. Advocate General may quit his office by submitting the resignation letter to the Governor of the state, not to the Chief Minister, not to the Chief Justice of the High Court, etc. Because Governor is the appointing authority of the Advocate General. So, if Advocate General want to resign the post, he should write his resignation letter to the Governor of the state. Who decides on the remuneration of the Advocate General? The post of Advocate General is established by Constitution, but the removal procedure and remuneration is not fixed by the Constitution. So, Advocate General receives such remuneration as Governor may decide. For Advocate General, Governor decides about the remuneration. For Attorney General of India, that is President of India, decides about remuneration. From here onwards, the rights, duties, limitations of the Advocate General is very similar to the Attorney General of India. So we discuss in detail about duties, rights, limitation in the Attorney General. Please refer to that. Here we briefly discuss about these topics. Now let's discuss about the duties of Advocate General. Advocate General holds the and should advise the state government upon the legal matters which are referred to him by the governor. Advocate General should appear on the behalf of the government of state in all the cases in High Court or District Court in which state government is concerned or is a party. Now let's discuss about the rights given to the post of Advocate General. The article, that is 177, deals with the rights of the Advocate General with respect to the House of the State Assembly and its committee. Advocate General has the right to present in all the courts within the state, whether lower court or district court or in High Court. Advocate General has the right of audience in all the courts within the state. Advocate General has the right to speak or take part in the proceedings of both the houses of state legislature. As you know, state legislature has two houses, lower house, the state legislative assembly, and upper house or Vidhan Parishad. Only 5 to 6 states in India has both the houses, and most of the states have only one house, that is state legislative assembly. We'll cover in detail when we cover about state legislative assembly in our another video lecture. And also Advocate General has the right to speak and take part not only in the houses of state legislature and also in its committees, any committee, but he should be a member of that committee. Without membership, he can't attend the meetings of that committee. So he should be a member of the committee so that he can speak and take part in the proceedings. The another important prelims point is that Advocate General enjoys all the privileges and immunities that are available to the members of the state legislature. Here, just a comparison. Attorney General of India has all the immunities of MPs. Advocate General has all the privileges and immunities available to MLAs. Remember this point for prelims examination. Article 194 deals with the powers, privileges and immunities of Advocate General. Till now, we compared Attorney General of India with the Advocate General by mentioning the various articles, numbers. Here you may get confused how to remember the articles. For that, you have to revise a lot the important articles by comparing these two, Attorney General and Advocate General. First, constitutional position. Attorney General established by Article 76. Advocate General post established by Article 165. And rights of the Attorney General or Advocate General with respect to the House of Parliament or State Assembly. For Attorney General, the article is 88, and for Advocate General, article is 177. Powers, privileges and immunities. Here equal to MP, here is equal to MLA, that already we discussed. Article 105 for Attorney General and Article 194 for Advocate General. Now let's discuss the various limitations on the powers of Advocate General. This is important for the prelims examination. The first point is that Advocate General has no right to vote in the proceedings of the state legislature and its committees. Already you know, Advocate General has the right to speak or take part in the proceedings of the state legislature as well as in its committees. The second point is that Advocate General should not advise or hold a brief against the government of state or India. Third point is that Advocate General should not defend the accused persons in the criminal prosecutions without the permission of state government. We already discussed in detail about these points in Advocate General of India topic. The fourth point is that Advocate General should not accept the post like director in any company or corporation without the permission of the state government. Advocate General is not a full-time counsel for the state government, and Advocate General does not fall in the category of government servant. So he is entitled to do the private legal practice. He is allowed to do the private legal practice, but he is not involved in the case against the state government. And also in the criminal prosecution cases, he should get the prior permission from the state government. Now let's compare the features of Attorney General and Advocate General. Attorney General is appointed by President of India, whereas Advocate General is appointed by Governor of the state. To become an Attorney General, A person must be have the qualified to become a judge of Supreme Court. To become an advocate general, a person should have all the qualifications to become a judge of High Court. Attorney General holds a post during the pleasure of the President, and Advocate General holds the office during the pleasure of the Governor of the state. Both Attorney General and Advocate General posts are constitutional posts. Attorney General post established by Article 76, whereas Advocate General post is established by Article 165. Remuneration is fixed by the President of India for Attorney General, and for Advocate General, remuneration is fixed by Governor of the state. The another point is that eminent jurist can become a Attorney General. Here, eminent jurist cannot become the Advocate General. For more details, watch our High Court and Supreme Court video lectures. That's all about Advocate General of India topic, and download a PDF for the revision purpose, and all the best for your 2016 IAS exam preparation. If you have any doubt, our WhatsApp number is 809-809-9922.